Welcome to Aspen Leading Edge. I'm Patty Roberts at St. Mary's University School of Law. Today's guest is Andrew Manuel Crespo. He is the Morris Wasserstein Public Interest Professor of Law at Harvard Law School, also serves as the Executive Faculty Director of the Institute to End Mass Incarceration. Welcome, Professor.
Thank you so much for having me.
Well, I'm really excited to have you on because there is a lot of buzz about a first edition book that you have recently co-authored, Criminal Law and the American Penal System. But before we get to that, I wonder if you can tell us a little bit about the work of the Institute to End Mass Incarceration and where your interest in this really important topic arose from.
Well, I so appreciate the chance to talk about all these different facets of work that are really my life's passion. Teaching and trying to do something about urgent social problems in our world are the reasons I came to law school. I actually hadn't planned to be a law professor. When I was a student here, I was very involved with our law review, and as a result, some of my mentors would ask me, "Oh, do you think you want to go into teaching?" And I, with what I now realize in hindsight was probably a bit of offensive hubris, would say something like, "No, that's the one thing I know I don't want to do." I said, I want to go be a lawyer. I want to go practice. I want to go help people," which is what I did. I was a public defender for over 3 years in Washington, D.C. I was a trial attorney. After having done 3 years of appellate clerkships, went down into the trial trenches and so loved that work and think often of the people who I saw on the front lines of the American penal system. Both the clients who I represented, my youngest client was 8 years old, my oldest client was in his 80s, but the vast majority of them were young black men in their teens and 20s. I think a lot about my clients and what I saw of the circumstances surrounding their lives that led to their court cases. And I think a lot about the complaining witnesses in the cases. I think a lot about people who I know my clients hurt. It's actually, I think, something folks don't realize so much about public defenders. I spent so much time in the living rooms of the people who were complaining witnesses in these cases. More time, really, than the detectives usually had. And the fact that I was willing to give so much time, I think, was why they would open up and talk to me. And I feel like I had such a rich sense of how much both crime and punishment don't work in our country. How people are hurt, and the people who are hurting people are usually themselves hurt people. My clients were usually victims of real harm themselves. So I came to this work from seeing it up close and personal as something that had impact on real people who I knew and who I cared about and who I had spent time with. And I thought for a stretch that that was going to be my work, that I was going to be a public defender. And I think back with a lot of gratitude, actually, to a professor here who was the dean at the time, Martha Minow, who reached out to me early in my career and said, you should think about teaching. You should really think about coming back to Harvard to teach. And she said, if you do that, there'll be 3 really special things that'll happen. You will get to think about the big picture issues that are tying together all of these dozens and dozens and dozens of cases you're seeing, all of the things that are bothering you about this system that you're seeing every day. You get to think about it as a system and focus on those core questions and try to figure out what to do about it. Then she said, you will be able to build something. You'll be able to have a platform and the resources to try to build something, to do something about the issues that you care about. And she said, you're going to meet the most amazing people. You're going to meet colleagues who inspire you and students who inspire you even more. And everything she said has been true. Getting to build the Institute to End Mass Incarceration alongside Premal Daria, who co-directs it with me, has been a major effort of my professional life here at Harvard for the past 4+ years. The Institute is built around a theory of change that says that it takes mass social movement power to really change the deep structural challenges in our society. That it's not, you can't sort of white paper your way out of some of the entrenched structural challenges. You need real people power. But also, we think that there's a role for lawyers in that work. And a lot of what the Institute does is try to hone and develop a mode of lawyering in partnership with organizing in service of supporting decarceral grassroots movements. We're sort of like in-house counsel to on-the-ground campaigns. We've been deeply embedded in one campaign trying to halt the construction of a prison in eastern Kentucky for 2 years now. And I love teaching students in that work. I sort of spend half my year up at the podium teaching criminal law and criminal procedure, and half the year with 8 to 10 students rolling up our sleeves trying to do the on-the-ground work that the Institute does. They're 2 very different hats, and I sort of feel very different in them. One is a forward-leading, experiential, engaged mode of practice and teaching through that practice. And the other is really stewarding first-year students through an intellectual, what I hope is an intellectual awakening and an intellectual experience that is leaning into all of the complexities and hard questions that live at the intersection of criminal law and the American penal system, which is the title of the book that John and I have finally just finished writing.
Well, I love that you bring a public defender's lens to this important work you're doing, leading and training students and grassroots organizations to change the systems that we seem entrenched with right now as a society and as a nation. So you're doing this important work. Martha Minow wisely brings you into Harvard, back to Harvard. She and others see the potential for you leading these kinds of efforts. At what point do you and John Rappaport from Chicago, the University of Chicago Law School, decide we should write this book?
Well, I have to say just a word first about John, who is a dear friend and also like the co-author from heaven. This has been such a collaborative project, and I just feel so grateful to have gotten to do it with him. John and I have been friends for a long time. We clerked for the same judge years apart, but then really became good friends while I was clerking for Justice Stephen Breyer and he was clerking for Justice Ruth Bader Ginsburg. So we spent a year together at the Supreme Court and just became dear friends, and then stayed in touch as we both found our way into the academy. And we were a couple years apart, but we're basically junior professors together. I think that I have been wanting to write this book since roughly my second semester teaching, which was the first time that I taught criminal law. I arrived on campus to teach criminal law to first-year students straight from my job as a public defender. I started at Harvard in January of 2015, and in, November of 2014, I was trying my last homicide trial. I'd come straight from the front lines of the American penal system and was now figuring out, how do I want to teach students about what they really need to know to understand how this system works? And I say this with tremendous admiration and respect for all of the colleagues who have been teaching this subject for so long, but I felt real frustration. I felt like the conventional way of teaching the class was failing to really center the core issues that both scholars and students think of as the central themes of this body of law. I realized the scholarly disconnect as I kept going on through my career, as I was writing my pre-tenure papers and really seeing where the scholarship in the field was at. Scholars are writing about mass incarceration and the role that criminal law and lawyers and legal actors have played in constructing the largest system of human incarceration in the history of the world. Everyone knows that the United States is a tremendous outlier, both in the scale of its prison system and in the disproportionate racial impact. In our scholarly lives, most of us in the field are writing about that. We're trying to understand why it happened. We're trying to understand how it happened. We're trying to understand the relationship between law and this phenomenon. And we're trying to think about what sorts of legal interventions might be useful to engage with that state of affairs. And our students now, much more so than when I was a student here, come to law school expecting their 1L criminal law class to be about those issues. This is the first time in history that we have a generation of students who are arriving on campus having lived through not one, but two major periods of social protest over these issues. First, starting in the wake of Michael Brown being killed in Ferguson, and then after George Floyd's murder in Minneapolis. These students come here knowing something about these issues and also knowing that these were sort of front page headline issues. Many of these students have been active in this. Some of them were marching, some of them were working in offices working on these issues. For some of them, this is why they come to law school, and they expect their criminal law class to be deeply engaging with the question of what's the relationship between law and this system that they have some familiarity with. And that was true when I first started teaching. I joined this faculty here months after the protests in Ferguson. And then I sat down to try to build a syllabus. And I looked at the materials that were out there. I looked at the leading case books. And I just saw that they weren't built for that to be the central narrative of the class. And part of that is just there are two case books in particular that many people in the field use. And this is no knock on either of them, but they both have first editions in the late 60s and early 70s. And I know now, well, having just finished the first edition, like a book's DNA gets encoded in that first run. And the prison population in the United States goes vertical in 1973, right? Those are books that are written before this sea change in how the prison system operates. And so I think many, many colleagues have been trying to struggle how to bend and adapt a course structure that was in many ways predated that defining social phenomenon to try to find ways to get it in. And I was doing that from the first semester. Every year I felt like I was bending more. I've sometimes told my students, I have this image of an old Wile E. Coyote cartoon where he tries to bend the tree, and usually the tree snaps back up and just flings him off into the horizon. You see the little puff of smoke. And I thought, oh, look, I'm either going to keep bending this tree and it's either going to snap or it's going to fling me to the horizon. I need a tree that's roots are planted in the right spot. I need the whole thing to be grounded in a course that is about the role that law and lawyers have played in constructing mass incarceration and the complexities of mass incarceration and the deep moral complexities of criminal law, and that helps students understand criminal law as a product of the society that authors it, as in some ways a major tool for reinstantiating aspects of that society, and also as an instrument of law enforcement power. Substantive criminal law does two things at the same time. It is a tool of accountability for all the reasons we usually talk about. It's either trying to promote retributive aims or to deter people, but it's also a tool. It's also a tool that helps police officers solve crimes or prevent them, that helps prosecutors resolve cases through plea bargaining, which is the major engine of how our system operates. And I think students need to know that part just as much as they know the substantive content and the sort of more detached, frankly, arguments about why one should have a criminal law in a society, rather than asking the hard questions of how exactly is criminal law operating in this society when it's a society that's marked by some real historic inequalities that shape the criminal law and that allow the criminal law as an instrument of power for law enforcement actors to be used in ways that produce the largest system of incarceration in the history of the world.
So when you're connecting those core doctrinal concepts to this idea of this vertical dramatic increase in incarceration that is impacting particular populations more than others, how do you do that in the book? If I'm a student in your criminal law class, how do I see this in the book?
Yeah, it's a great question. So the first thing I want to say is one of the hardest balances John and I were trying to strike, and that I really hope and think we landed well, I'm really proud of, is we think of this book as conceptually novel and hopefully paradigm shifting in certain ways, while being pedagogically conservative. In other words, it is still very much a case book, and it is still teaching core doctrinal concepts. Students who take a class with this book are learning the sort of important role of mens rea and tiered layers of responsibility in assigning criminal punishment. They're learning about doctrinal concepts of actus reus and omissions and justifications and excuses. They're learning the details and nuances of self-defense law. They're learning about complicity liability and conspiracy liability and how attempt doctrine can vary from one place to another. They're learning things that also are not always covered in other classes, like the law of possession and theft and shoplifting. But the core backbone of the class is a doctrinal course. Every one of my lectures is close reading of cases that is teaching students the essential lawyerly skills that you want them to learn in a first-year classroom. How do you read a case well? What are the arguments being posed here? So the conceptual innovation comes in a few different ways. So first, the book starts with a chapter that is an introduction to mass incarceration. It starts that gives an overview of the history of prisons in the United States, a sense of the scale and demography and international comparisons, and it also includes an extended set of short excerpts from people who are writing from inside of prison. We want from the very beginning to make clear that this is not just numbers. There's a short quote we have at the beginning of that section from a man named Arthur Longworth, who had been in prison for about 30 years at the time he wrote it, where he says, to many people, mass incarceration is about numbers. And that makes sense. The numbers are overwhelming. But for me, he says, mass incarceration is sewn into my bones, keeps me from breathing. And we have this extended set of passages that are about what life is like inside of prisons, so that the students start off the semester understanding what it is they're trying to understand. This is the phenomenon that this class is about. And the question is, how did law help constitute that? We then go into a foundational chapter that will be familiar to many people who teach the class, which is looking at the traditional justifications for punishment, retributivism, utilitarianism, and expressivism. Although even there at the beginning, we include some important work from philosophers about the idea of the state's standing to punish. As we want to question from the beginning the idea, or have the students ask, look, does the state's authority to punish, is that impacted in any way if the state itself is partially responsible for criminogenic forces in society? We want them to grapple with that from the start, and that leads into a sort of third chapter in the foundation laying part of the book. It took us a while to figure out how to teach this, but this chapter we're really proud of because this chapter is giving students something that I don't think any other casebook has, which is a primer on about a century's worth of sociology that explains what causes crime. Every criminal law class I've been encountered basically takes the quote-unquote criminal at the moment that the case begins. They're just dropped into our narrative life as the reader. It's like, all right, here's the appellate case, and it started with somebody shot somebody or somebody stole something. The crime is the beginning of the story. It's almost the opposite of Brian Stevenson's adage to all of us to not just assume that people are the worst things that they've ever done. So we wanted to contextualize crime and give students a sense of the sociology and the social structures that cause crime. The way that we teach this, and this is sort of out of order for how the class is often taught in other contexts, what we think is a really foundational, helpful way to start is we teach students about the insanity defense and doctrines like infancy in the first week, really, because we want them to understand that sometimes the criminal law says that there are people who do things that are hurtful and wrong, and yet they are not eligible for punishment because of circumstances outside of their control. They might be 12. They might be schizophrenic. There might be external things that mitigate to the extent of making them ineligible for punishment. And then we ask the students to revisit the debate from the 1970s over whether or not law should recognize a poverty defense, what was sometimes called a severe economic deprivation defense or the rotten social background defense, which no court ever took up, even though there were some strong dissents and some real academic arguments that it should be treated just like insanity, that there are here too forces outside of people's control, namely they were born into poverty, that are also contributing substantially to their criminal offending, which if you ask any sociologist in the country, they'll tell you, yeah, of course. If you have someone who grows up in poverty, they have much higher risk of engaging in these types of behaviors. In other words, crime is a product of social decisions we've made, of social policies, of decades and centuries of inequalities. So we ground the class that way. We then have the sort of next major chunk of the class be a move through three core, what are often called mala in se crimes, core crimes, right? Homicide, sexual assault, and property offenses. And in this section, our goal is to do two main things. One is to teach students the basic doctrinal building blocks. One thing that our book does that is unusual is we don't have what's called a general part. A lot of criminal law casebooks have a general part where they have a chapter on mens rea and a chapter on actus reus, chapter on justification. We teach all of those concepts through crimes. In other words, we teach mens rea through teaching the law of homicide. We teach a lot about actus reus through teaching the law of sexual assault. We teach a lot about justification through self-defense in the homicide chapter and through things like economic necessity defenses in the property crimes chapter. We realized that this was freeing in many ways and also made a lot of sense because the reality is no one's ever in an indictment charged with having a mens rea or having done actus reus, right? They're always charged with a crime. And then you figure out what's the mens rea or the actus reus. So it's natural to teach the concepts through crimes. It actually flows beautifully and it economizes for us. It makes space for us to teach a lot of the other things we want to do in the book. So these early crime chapters, homicide, sexual assault, and theft, are teaching some doctrinal building blocks, but they are also in each one highlighting for students the kind of core law and society thesis that law is a product of the society that writes it and also helps reinstantiate that society. So a lot of the discussion in the homicide chapter is about race and violence and how our ideas of violence are informed by and seen through lenses of race. A lot of the themes in the sexual assault chapter are about how historic gender hierarchies shaped the law. That's just undeniable, right? A law that used to literally say that women were the property of their husbands and that authored rape law in that setting is going to have all sorts of features of the doctrine be shaped by that power structure. And so too with property crime. Our property crime chapter is half on shoplifting and then directly into white collar crime. And juxtaposing those two, we want students to see how the system treats differently crimes of theft, in some ways depending on the social standing, the class standing of the person who's accused. So that's a kind of core middle part of the class. And then I'll say, just to sort of tie up the thought, because I realize I can talk forever about this book, but the last real chunk of the class is then moving into the idea of criminal law as an instrument of law enforcement power. So here, when we're teaching complicity, conspiracy, and attempt, we want the reader and the student to appreciate that some of these doctrines are actually just really, really valuable to law enforcement actors who have a mission that's assigned to them by all of us to solve crimes and critically try to prevent them. The move from police as the agents who try to solve crimes and to have only a backward-looking function to try to catch people who had caused harm, to being the agents we hold most responsible if a crime happens. You know, the idea that the time that the police commissioner is most sweating at a podium in a press conference is if crime rates are going up, where it's like, we think of the police, their job is to stop crime from happening. Well, how does criminal law help them do that? And here we take the students through ideas like showing how conspiracy law is actually, in many ways, perhaps an instrument of information forcing. How do you sort of get the little fish to flip on the medium fish to get to the big fish? And that might explain why criminal law doctrine lets you punish the little fish incredibly severely in ways that seem maybe out of whack with the retributive proportional principles earlier in the book. And we try to explain to the students, look, this might not just be hypocrisy. It might be there's a reason why they're breaking from that proportionality. It's instrumentally useful to be able to really squeeze someone on the outside of a conspiracy if that's the only way you can get information on the inside. So too with attempt, we show them how this is allowing the police to act sooner and to create crimes that are in some ways proxies for the things that they are really trying to stop. And that leads us into teaching possession right alongside attempt. And so one thing that our book does that a number of others don't is we really emphasize drug and gun possession as crimes worth studying and knowing about. But we want the students to also see that possession itself can be a tool of potentially expansive police power. If you criminalize things that a lot of people have, like say a marijuana cigarette, you are not just enacting a certain set of drug policies, you are creating law enforcement policies. You're making it possible for the police to potentially put someone up against the wall anytime they smell marijuana and go through their pockets, perhaps to try to find more serious evidence that they're looking for. But at this point, the students appreciate that there's a connection between substantive criminal law and broad police power and mass incarceration. And that takes us into the concluding part of the book where we teach them a lot about plea bargaining and give them capsule sort of 1 or 2 week lessons on how constitutional law ties into all of this. We give them a sort of introductory set of lessons on the Fourth Amendment and on street policing. And then we give them quite a bit about the constitutional law that, in our view, I think the message we hope they come away with is does not regulate plea bargaining very much and does not constrain the state's ability to enact criminal laws. So they sort of start from doctrinal concepts, move into criminal law as an instrument of law enforcement power, see how that power is then used to generate the system as it exists, and engage with the reality that relevant constitutional doctrines are not imposing a check.
Wow. I can see why there is so much excitement about this book. And I can see where students will just absolutely engage in the classroom in a way that perhaps a traditional criminal law course would not be able to inspire. I love that you have a sociology chapter and you look at that. It made me think locally we have a judge who has a reflejo court, and it is for those who are accused of engaging in crimes related to domestic violence and abuse, but who then, when you further look into their histories, are of course the product of such abuse in their homes, and how that certainly impacts those who then engage in the crimes. The fact that you've intertwine the doctrine within the context of the crimes themselves. That's got to be a much easier way to learn these concepts. Very effective. So super exciting that you have explored the American penal system in the context of criminal law. And I'm really looking forward to hearing what the feedback is from professors who adopt this and from students who learn from it. But you're right. Our students, especially who have lived through Ferguson and George Floyd, they are coming to us, to law school, to help solve these problems because these absolute abhorrent situations are things that they want to address. They want to make a difference in this world. And if we don't talk about it when they get here, how crushing that must be. So I applaud you and John for really bringing all these tough topics into that first year criminal law course. The Institute to End Mass Incarceration, having an experiential learning opportunity for students, is also very exciting. I understand you have a magazine connected with the Institute. Can you share a little bit about that?
Yes, I can. The Institute launched about 4 years ago. And the day that we launched a magazine called Inquest, which I'm just so incredibly proud of. If you'll permit me just a second of lack of humility, the Inquest was just recently named a finalist for the National Magazine Awards alongside, the New York Times, the New Yorker, ProPublica, the Atlantic, and so many other tremendous publications in the country. And
Incredible. Congratulations.
Thank you so much. Thank you. Yes. One of my joys with the casebook actually is how many Inquest essays are excerpted in the casebook. Inquest is a magazine that is focusing on ideas about mass incarceration and ending mass incarceration. One of the things that I love most about it is it's not primarily or exclusively for lawyers or legal academics. We publish lots of lawyers and legal academics, but we publish so many different types of voices and people with so many different experiences. We publish public health officials who understand prisons as what we learned during the pandemic can be called epidemiological pumps, that they are sort of vectors of lots of public health challenges and can actually pump diseases back into communities. We publish judges who were a public defender who ran for office as a judge and why they did that. We publish about 40% of our authors are directly impacted by the system, and more than 20% are writing from prison. We publish philosophers, we publish historians, we publish sociologists, we publish a lot of organizers who are writing about their work and their campaigns. And I was so pleasantly surprised at how much that material actually makes its way into the book. I should say, though, and I want to emphasize this to all your listeners, so John and I were both public defenders before becoming academics, and maybe hearing me talk about the system and the work I do with the Institute, I could imagine one thinking like, oh, okay, so this is a casebook that's like about like how awful the prison system is and how everyone should just like agree with what Crespo says about that and what Rappaport have to say about that. And I want to emphasize that I think one other thing that we tried to do really well in the book, and I hope executed well, is we want this to be a book that is broadly available to professors and students across what we know to be a broad range of thoughts and perspectives about the American penal system. In my life running the Institute, I'm an engaged scholar who's trying to have an impact in the world. But I am also an academic and a scholar. And one of the things that I love about having to have these sort of related but different hats is, when I'm in my 1L criminal law classroom, I am leaning hard all the time trying to emphasize for my students, these are hard questions. These are hard questions that actually don't have easy answers. And I might have answers that I've landed on as ones that I'm comfortable enough to take action on, but I'm always skeptical. I'm always questioning even my own conclusions, because that's what this whole enterprise is about. These are challenging, hard questions. So we tried very hard in the book to give a critical analysis, or at least the space for a critical analysis of the role law and lawyers have played in building mass incarceration, while also in both the presentation of voices, in our tone and in our presentation, to be scholarly about it, because we are two academics who actually appreciate and love the fact that this is complicated and that don't run away from that. And one of the things that has been a joy for me, so John teaches at the University of Chicago, I teach here at Harvard. These are both schools with ideologically diverse student populations. And we are both very much aware that a 1L criminal law classroom at most schools is one that the students don't get to pick the professor. And I feel a real professional obligation to my students to make sure that I am not trying to impose my own views on them, but rather I'm trying to draw out from them their own critical thinking. I'm always inspired by the idea that the word education comes from the Latin educere, which means draw out. Not put in, draw out from the students their own thinking on these things and give them space to encounter that. And I'll say actually, when I think of the feedback and course evaluations and just responses from my students, I have had students who are clearly dedicated prison abolitionists who say that they love the class and love the way the book is presented. And I have students who are, either head of the FedSoc chapter or going to clerk for judges who one would not think of as coming within the same room as a prison abolitionist, who also say how much they love the class because it is about leaning into all of those hard questions. I try and present this to the students as both complex legal issues and also contested moral questions. And I try to reframe it for them in a way that makes that feel less fraught. And I'll tell you, one of the main ways we do that is a lot of the book is actually highlighting how, and this is, I think, particularly salient at this moment in our political history, how it's not a clean Republican-Democrat kind of issue when it comes to the American penal system. There are tough on crime, carceral progressives. There are libertarian conservatives, and then there are progressive left decarceral folks and conservative tough on crime folks. And a lot of times the public discourse, at least until recently, presented it as if only those last two categories existed. A lot of our book and at least my teaching style, I often actually try to sometimes demonstrate the tension between the sort of more carceral progressives and the decarceral liberal students, because it helps showcase actually, look, this is much less monolithic than you think and more complicated. And so a lot of the book, we have a whole unit that, again, some books don't really lean into as much, on police killings, on police shootings, and on the law of police violence. You read that section and a lot of the students have some pretty carceral instincts, right? They're thinking, well, we need a strong, robust criminal law that can take down police officers who shoot folks. Then we move into the sexual assault unit, and there's a lot of, again, progressive students like, we need a strong, robust criminal law that can throw the book at folks who are engaging in this behavior. Then we get to white collar crime, and you have these progressives who are saying, we need a strong, robust penal system that can take on corporate actors. And part of what we try to do is actually demonstrate there are multiple fault lines here, and this is complicated along multiple dimensions. And I think that students, as a result, feel like in the classroom they find the fact that all those categories are being scrambled for them frees everyone up to say what they really think, because no one's getting pigeonholed. Everyone's grappling with the fact that there are swirling currents here. The last point I'll say there is, we highlight for our students that if you think that crime is in large part driven by sociological forces, and you think that we have a country with structural inequality tied to a legacy of racism, if you think that structural racism exists, and you think that structures drive crime, you should expect harmful criminal behavior to actually be concentrated in the same communities that have been neglected by decades of social policy. Once you say it that way, it becomes clear for the students that crime is concentrated in the same communities that are hurt by the problems we can identify in policing and mass incarceration. And so the same communities are living on both edges of that, and that too complicates the question of how you should intervene, because we have a responsibility to both, I think, mitigate and end the harms of our penal policy, and also address the harms of interpersonal violence, address the harms of scarcity that are then causing harms within communities. So I think the goal is to actually make it all seem quite complicated while not making it seem impossible to do something about. Rather, the goal is to show students there are so many entry points, and we need to have these hard conversations and hard debates in order to be able to take any kind of action. And the hope is to help them figure out what type of action they might want to take from a space of real critical engagement and reflection that's trying to meet each student where they are and, again, draw out from them their own critical thinking about these questions.
I appreciate that you shared that with us. And I was looking at the title of the book again, Criminal Law in the American Penal System, Cases and Context, by Aspen, published, the first edition just published. It's not criminal law in the mass incarceration system, right?
Sure.
Which it could very well have been if that was your approach and that was the result you wanted students to reach. But exploring our penal system overall and giving space to students on the spectrum of beliefs about what that system is like, and pushing back for them, or getting them to push back with each other to expand their view of what it should be like here in America. And I'm so glad that you and John Rappaport have done that, and that across the nation we'll have some of our brightest future lawyers and policymakers able to address these complicated questions. So thank you. And again, congratulations on the publishing of Criminal Law and the American Penal System.
I'm just so grateful to you for having me and for taking the time, and to all of your listeners. It's been 5 years of writing this book, and to get to share it with people is just such a joy, and I am grateful to you for making the time.
Well, you have to promise to come back, because I want to ask more about the inmates whose voices are amplified in the book, and more about how complaining witnesses you used to work with feel about that retribution piece, because I think we always assume that they want retribution and severe retribution. Maybe that's not always the case, since they're often in the same communities with the same sociological impact. The shortages of public defenders and prosecuting attorneys. I mean, there's so much I want to talk to you about, but we are almost out of time. So after the book has been out and professors and students are using it, let's schedule you to come back and talk more about these issues.
I would love that. I'd welcome that.
Before we conclude, though, I wonder if you can share with me what your thoughts are regarding the future of legal education in the coming decade. Do you imagine there will be changes? And if so, what might they be?
Oh my. I mean, you might have to have me come back for a whole conversation on that. Patty, I can't help in answering that question just reflect on the utterly dire and existential threat to higher education in our country right now. And I say that with hopes that across, again, a broad spectrum of viewpoints and ideas, that listeners who are working in academia, as I gather most of the audience of this podcast is, I expect are hearing my words here and feeling similarly to how I'm feeling, having just seen multiple weeks of efforts by our government to, in many places, try to break the back of higher education as it has existed, at least since 1915 in the American Association of University Professors Declaration of Academic Freedom and Tenure Rights. It took a lot of work to build American higher education into what it is. You know, with the short-sightedness of lifetimes that don't stretch long into history, we can sometimes forget that higher education in America was not always the sort of shining example in the world, right? Germany was the sort of birthplace of the modern research institutions. And it was really only over the past century and a half that we built American higher education into what it is today, precisely on principles of things like academic freedom and research integrity and free inquiry. And we had a government that respected that, more or less, until recently. And the break has been as sharp as I think anyone could have imagined. I think it has been threatens to be catastrophic, to be totally honest. When you have the federal government telling universities that they need to close academic departments and put them into receivership, when you have a federal government dictating what can be said on campuses and not, all at the risk of massive defunding, of potential investigations, including potential criminal investigations for things that I think most would recognize as squarely within protected speech. I have intense worry for the future of higher education, including law schools. If there is something that gives me some hope in that, it is seeing, and I can think of scores and scores and scores of them, faculty members across the country taking a stand in defense of higher education. I think it is critical, not just for higher ed, but for American democracy. I think that our universities are central pillars in our civic life, and they are important components of a free society. And I think that it is possible to break higher education. It's possible to break it in a way that would take another century to rebuild. And I have real worries that there is an actual concerted, powerful effort underway to do just that. And I have hope that faculty members, teachers, administrators, and students across the country who I think appreciate just how critical this moment of risk is will find ways to stand together, embolden each other, support each other, use our core skills of critical thinking and communication and reasoning, especially law professors. Some of the terrain of this fight is our terrain. It is legal terrain. It is in courts, and it will take both smart lawyering, smart thinking, smart reasoning, and I think moral courage. And I think that moral courage is hard to find in moments of fear, and this is, I think, a moment of fear, but it's also in moments of fear that moral courage is most appreciated, most recognized, most sought after, and I think most celebrated by those who recognize its need. And I certainly appreciate moral courage when I see it in academia, and I'm trying as hard as I can to encourage more of it.
Well, I think what all that has been happening has made clear is that our work is more important than it's ever been. And
Absolutely.
so we stand together and continue to do that work and show up for our students who will be the future leaders to make these decisions. But I appreciate your candor. And again, I want to congratulate you, Andrew Crespo, and your co-author, John Rappaport, on the new book, Criminal Law and the American Penal System, Cases and Context. And I enjoyed our conversation immensely. If you listeners did as well, I hope you will listen to other thought leaders in the Academy on additional episodes of Aspen Leading Edges podcast on your favorite podcast channels. Thank you.
Thank you.